We'll take you now to Kano, where Justice Mohammed of the Federal High Court nullified the candidature of the Abia State Governor-elect Alex Otti and all the candidates of the Labour Party in Abia and Kano States. The court ruled that their emergence was not in compliance with the provisions of the 2022 Electoral Act. A copy of the judgment delivered by the court was made available to newsmen earlier today. In the suit filed by Ibrahim Haruna against the Labour Party and the Independent National Electoral Commission, the court ruled that the failure of the Labour Party to submit its membership register to INEC within 30 days before their primaries renders the process invalid. The court held that any party that fails to comply with the provisions of the Electoral Act cannot be said to have a candidate in an election and cannot be declared winner of that election. The court thereby stated that the votes credited to Alex Otti are wasted votes. Joining us on the news to discuss more on the court decision is a legal practitioner, Olayinka Daniels. Thank you for joining us on TVC News at 7. I know that this particular judgment will be tested possibly up to the Supreme Court. And even though the Electoral Act and the Constitution recognizes the Federal High Court as one jurisdiction, are you concerned that the issue of territorial jurisdiction is a consideration here?
Well, in as much as the Federal High Court has jurisdiction over some matters, considering the power the Constitution has given the Federal High Court to adjudicate over cases like that. But then taking a case from, there's a Federal High Court in Abia State. Now, going to Kano to probably take a case against the Kano, probably the aspirant on LP in Kano. They're now joining the Abia to the Kano aspirant. I have personally, looking at the provision of the Constitution and looking at the power or the jurisdiction the Federal High Court has, I do not see the Federal High Court in Kano deliberating in what has happened in Abia. Unfortunately, even whoever that filed such case did not even join the aspirant. I'm sure that is the reason why the court was careful enough, because the prayer, one of the prayers of the petitioner was to return the certificate, was to invalidate the certificate of return, which the court did not granted. So the court was careful enough not to do that, because if the court has done that, the court would have gone overboard. The court was careful enough not to grant such order as to make it to invalidate the governor-elect of those parties. That was the reason why the court left that, because the court does not have that jurisdiction, so to say, to make such order. And that was why the court was careful not to make that order. Because what we are talking about is a pre-election matter. Whatever that will happen now, after election has been conducted, after we have, elected governors or elected aspirants, anything that will come after that will be to the tribunal. The right place is to the tribunal. For anyone that have issues, should go to the tribunal and contest it. Not going to the Federal High Court to then raise the issue of the register of the members of the party were not submitted 30 days before. INEC didn't have any issues with that. So if they had not followed due process, if they had not complied with the INEC regulations or what the law, the provisions of the law as to submitting the register of the members, I'm sure that would have been raised. And some of these matters were even raised in some of the Federal High Courts, even up to Supreme Court. And those candidates won. And the election was conducted. They were elected. So at what point, because I even understand, when I went through this, I understand that this matter came under a week or thereabout, and 2 weeks, we have a judgment from Federal High Court as to this matter. I think any issue right now should be moved to the tribunal.
I hear you.
Not
Very
Federal
quickly,
High Court.
let us take a look at the substance of the ruling. So this has to do with the failure of the Labour Party to submit its membership register to INEC within, 30 days before the primaries. Is that something you think the Labour Party presidential candidates should be concerned about?
Yeah, it should. It should, because that has been on, and he should be concerned about that. And not just him, every other person also should be concerned about that, because if it is found that yes, this membership register were not submitted, even at the tribunal, this can still make they can make a case for them. And the Labour Party presidential aspirant, he has to, I'm very sure that he has lawyers that are looking into all this, and they have to take cognizance of the fact that this can affect them, like we said, and it may not also fly. It depends on the prayers of the petitioner, and it depends on the counterclaim of the defendant in this particular matter.
Legal practitioner Laika Daniels, thank you for sharing your thoughts with us on the news tonight.
Thank you for having me.